He's actually.
It's good to see your smiling faces. I know we were a little sparse yesterday, so it's good to see more of us here in person today. I know we also have the Zoom option, so we have some folks online. So just don't be weary if you hear like a voice and you don't see someone's mouth moving. It's probably somebody on Zoom. So we are going to start our first ethics committee meeting for the year 2025. We're super excited about the work that we get to do on this committee. I appreciate you all serving in the capacities that you're serving and specifically serving on this particular committee. I'm sorry, I'm Dorothy Hairston Mitchell. For those of you who don't know me, I think we do have a few new members. So I am the chair of this committee, and then to my right is our vice chair, and I will let you do your introduction. And we'll go from there.
Good morning, everyone. Davis Poisson. I'm a bar counsel from Judicial District 21 in Anson, Scotland, and Richmond counties. Been about 5 years. I'm vice chair of this. Welcome to all the women.
My name is Nicole McLaughlin, and I'm one of the staff lawyers here in the State Bar.
So are we doing everything?
Yes.
Suzanne Lieber, I'm assistant ethics counsel. I've been with the bar about 18 years.
I'm Brooke Dennis, I'm the executive assistant for Brian and Peter, and I've been at the bar for a month. I'm Patty Head. I've obviously told them one too many times that I go by Patty. So anyway, I told them that Patricia was what my mother called me when she wanted my attention. And so I am formerly of Wake County. Have since moved to Littleton, North Carolina. I'm Lake Gaston. I am a public counselor. We have 3 in the state bar, and I'm privileged to be one of them, representing all of the people of North Carolina, as I know you do too, but I'm specifically titled with that, so nice to be with you.
Julie Bell, I'm a bar counselor here in Wake. I think yesterday I said it was my 5th year, but it's actually my 6th year on the council, and delighted to be here. And I serve as a district court judge here in the 10th Judicial District.
I'm Tom Langen. I'm a bar counselor for Surrey and Stokes County, where I also serve as a district court judge, my 4th year on council.
Good morning, I'm Fran Muse. I'm an advisory member from Orange and Chatham counties, and I think this is the beginning of my 4th year.
Good morning, I'm Jeff Foster. I'm bar counselor for the 3rd District in Greenville. I'm also a Superior Court judge, beginning my 2nd term as that this January, and this is my 2nd year on the council.
Hi, my name is Elizabeth Johnson. I'm an advisory member, and I'm starting my 2nd year.
Kevin Kiernan, 7th year bar counselor from the 5th District of Onslow, Sampson, Duplin, and Jones.
Good morning, Jane Hinkle, a lawyer here in Raleigh with Smith Anderson, and an advisory member having just joined at the last meeting.
Good morning, everybody. My name is Brian Long. I'm currently serving as an emergency Superior Court judge after retiring as a Superior Court judge. I'm a brand new counselor from Judicial District 39, which is Ashboro, replacing the legend Clark Bell.
I'm Gina Morris. I'm a family lawyer with James McElwain Deal in Charlotte, and this is my 7th year on the council and 7th year on the ethics committee.
I'm Wade Harrison. I'm from Alamance County, District 17. I'm bar counselor. This is going into my 3rd year. I'm Bill Rogers, Concord, 25th District, Bill Rogers, family law. This is my 3rd year on the council.
I'm John Leidy. I'm the representative for the 1st Judicial District, which is the northeastern corner of the state, and this is my 3rd year on the team.
Good morning, Crawford Cleveland. I'm an State Bar Counselor from Boone, Blowing Rock area, Judicial District 35. I'm a university attorney for Appalachian State.
Cindy Batchford, law attorney here in Wake County. I have been, I think, on the ethics committee for 4 years. I'm an advisory member.
I'm David Allen from Charlotte. I'm an advisory member. I try to do civil litigation whenever I can in Charlotte. I've been a veteran of the
Good morning, I'm Julia Ambrose. I'm a lawyer here in Raleigh with Brooks Pierce. I am an advisory committee member also, and this is my second meeting.
Good morning, y'all. I'm Hunt Quinn. I am from Union County. I am that district's bar counselor, and I am a retired Superior Court judge. And I'm about as new to this process as you can possibly be. This is my first week.
So welcome.
I'm Jay Vanoy, I'm from Wilkesboro, I'm the 34th District, Wilkes, Ashe, Allegheny, and Yadkin counties, and I'm a trial lawyer.
Ellen Murphy, I'm an advisory member. I'm a legal ethics professor at Wake Forest.
I'm Craig Lynch. I practice commercial real estate law in Charlotte, and I've been on the council for 3 years and been a part of this committee for 3 years.
I'm Stacy Cordes. I'm also from Charlotte. This is my first year as a counselor, but I've been an advisory member to ethics for the past 3 years. I practice bankruptcy, and I'm excited to be a counselor.
Wonderful. My name is Nancy Norelli. This is my 10th year on the council because I'm back for another stint. I'm new. But I'm also old. I'm pushing up on that 50-year lawyer fun thing. And so I'm really thrilled to have a way to put all that experience to work again. Hated the pasture, hated it.
I'm Anna Davis. I'm a newly elected bar counselor in Wake County. I was elected to the Savage seat, which was savage. Mr. Savage is not quite ready to let me go on my own, but he's here beside me. Grateful for his mentorship. I was an advisory member for 7 years on the Authorized Practice Committee since 2017 till now, and I'm a lawyer for the City of Raleigh. I work with the Raleigh Police Department.
Warren Savage, I'm a claims attorney at Lawyers Mutual. I have been, I'm a former counselor, I'm an advisory member now, and was an advisory member before I was a counselor, so, and all of that on the ethics.
Last but not least.
Good morning, everyone. My name is Ashley Parker. I'm a bar counselor, the newest of the new bar counselor from Wake County. I think we're a little cliquish over here. We're missing Judge Bell. And I'm a district court judge here in Wake County, and I'm also the chair of the CLE committee. So pray for me.
He's been doing great already.
And I'm Brian Oden. I'm the Associate Director of the Bar and the Chief Ethics Council. And we have some folks on our call. So I'm going to call on y'all. Nobody can see you in this room. You're just going to be the voices that appear out of a little thing right in the center of the room. So we're going to start with Takia. Takia, can you introduce yourself?
Yes, hey everyone, I am Takia Lewis Blaylock, and I am a counselor for District 7, which is Hertford, Bertie, Northampton, and Halifax counties. As of January 1, I am a district court judge, and prior to that, I was in private practice. So I have been on the council since 2019 and been on ethics since I've come on board, and so I'm excited to start a new year with ethics.
Thank you. Heidi.
Hey everybody, I'm Heidi Bloom. I'm probably what they would call a Klingon. I was a state bar counselor for 9 years and can't seem to let it go. So I'm now an advisory member from the 10th Judicial District, and I am a domestic lawyer.
Thank you. Martin.
Good morning, I'm Martin Scott from the 15th District, Columbus, Bladen, and Brunswick, and I'm a general practitioner, and glad to be with y'all from snowy Columbus County.
How about Tara?
I'm Tara Gore. This is my 4th year as an advisory member on the committee. I practice criminal defense in Brunswick, Bladen, and Columbus, same district as Martin, and I'm happy to be with y'all for another year.
Thank you. Nancy.
Hi, I'm Nancy Grace. I am a 3rd year on the council from the 10th Judicial District, family law attorney with Wake Family Law Group here in Raleigh. And this is also my 3rd year on the ethics committee.
Eddie.
Good morning, Eddie Thomas Jr. with the Mecklenburg County Public Defender's Office. I'm Assistant Public Defender. This is my 2nd year as an advisory member on the ethics committee.
Thank you. Lori.
Hi, I'm Lori Vitale. This is my 3rd year as an advisory member for the Ethics Committee, and I practice in Wake County. I do family law.
Great, and Mike, are you there? Mike Ramos is on the call. I'm not sure if he's present right now, but he's one of our counselors as well. All right, that's introductions.
All right, thank you, everybody. Again, welcome. We usually have at our first meeting of the year an orientation. We are not having that today for in the sake of time and because, you know, we all modified the schedule today. And so I do want to give an opportunity to Brian. He has a few things he would like to speak.
Just a couple of quick things. When I was starting to think about the orientation for this morning, particularly for our advisory members, and I realized that all of our advisory members have already received those materials because I don't think we have any brand new advisory members. So we have new counselors, and the new counselors saw a little bit about the process. We talked a little bit about it on Tuesday afternoon during the orientation. But you'll see in that SharePoint folder, and I'm just going to email it out to the entire committee, the slides that I put together for the orientation, because it has the information about what you can expect here, how to get engaged. We really do want everybody to be engaged as soon as you feel comfortable. So take a look at those materials. If you have questions, contact staff. That's probably the best way to get the information that you need, whether it's a question about procedure or just why something happened the way it did. Don't hesitate to give me a call or Nicole or Suzanne. We're happy to talk about this process and make sure that you have the information you need so you can jump right in. And I see we had somebody else that just popped in. Want to say hello to everyone, Bill?
Oh, yes, I'm Bill Powers, and I'm from Charlotte, North Carolina, and I'm an advisory member, third or fourth year, I can't remember. Glad to be here.
That's all I have to say.
All right, so with that, we will get started, and I'll read our statement as usual. Members of the committee are hereby advised of their duty under the State Government Ethics Act to avoid conflicts of interest and are instructed to refrain from participating in any matter coming before this committee with respect to which there is a conflict of interest. If you have a conflict that you know of at this time, please let us know. If you realize later as we're speaking about things that you have a conflict, let us know at that time. And with that, we will go to our special agenda items, administrative items, report on trust account audits. And, I was looking for you.
Good morning. Good morning. Morning, everyone. I'm Ann Parkin, the Director of the Trust Account Compliance Department, and I was the former field auditor. So I'm going to present just some highlights from the full audit report. Audits for the fourth quarter were conducted in Alamance, Davidson, Oak, Lenoir, Mecklenburg, Moore, Pitt, Union, Wake, and Wayne counties. One audit each was conducted in Alamance, Davidson, Lenoir, and Moore counties. Two audits each were conducted in Oak, Union, and Wayne counties. Three audits each were conducted in Pitt and Wake counties. 5 audits were conducted in Mecklenburg County. 2 new counselors were also audited. The 2 most common rule violations found were that 43% failed to complete quarterly transaction reviews and 38% failed to escheat unidentified or abandoned funds as required. Based on the geographic plan for 2025, audits for the first quarter will be conducted in Chatham, Davidson, long list, Durham, Forsyth, Franklin, Granville, Guilford, Johnston, Lee, Mecklenburg, Orange, Pasquotank, Surrey, and Wake counties. Any questions?
All right, thank you so much.
I want to, if I can, just offer a quick little thought on the new random audit selection process. You heard a lot of different counties being listed there, and you know, before it was kind of a report of there's going to be audits in maybe 3 counties or what have you. Last year, the council put into effect this new random audit selection where everyone in the state is in the same pool instead of selecting a particular district and pulling random audits from a particular district. We saw that was resulting in lawyers in smaller districts being selected more frequently for random audits, and lawyers in larger districts like Mecklenburg and Wake being rarely selected. And so everybody is basically in the exact same pool, everybody has the same chance of being randomly audited, and we saw from 2024's numbers that the change has really had the correct effect the council was looking for. In 2023, just some quick numbers, 2023, Wake and Mecklenburg had about 48% of the lawyer population, but only about 9% of the audits in 2023. Whereas in Alamance has just under 1% of the lawyer population, but had almost 5 or 4% of the random audits. 2024, complete switch. 95 lawyers from Wake and Mecklenburg were audited, which represented 47.5% of the random audits. So 47.5% of the random audits were in the counties where 47% of the lawyers exist. And only one lawyer ended up being selected from Alamance, which represented 0.5% of the audits for the entire year. So the change that the council put in place for the random audit, I think, was effective, and it had the intended result. And to the extent that you're talking with anybody out there about being selected for a random audit, I know I've heard the grumbles myself, but this new process is very much a better process and very fair for all lawyers in North Carolina. So just wanted to give you those quick results.
Can I ask a question about how much education you all have done in regards to this?
With the random audit process, yeah, we try to get it out there. We put it in the journal. There's something on the State Bar's website. I speak at a variety of CLEs. Warren and I did a CLE was it last week or 2 weeks ago, and talked about this. We talked about it in the Bar Association's, I guess they have their annual series that Peter and I do. So we try to get the word out there, but we can only do so much, especially, I always liken the State Bar's communications similar to communications from the IRS. Nobody's really looking for content from the IRS. They're just trying to hope to not interact with them. And I understand other folks feel the same way about the State Bar. So I can put out a really entertaining tweet about the random audit, but nobody's trying to read a tweet from the State Bar. So we're trying to get that out there, but that's where you all can really play a great role. Because you can take this information, you can, to the extent that it comes up, I know it may not be the top lunchtime topic, but still, just in talking about your experience at the bar, and just to kind of say, hey, I heard they did this differently, especially those of you that are in smaller districts, to be able to say, the bar actually made a change that's really beneficial to everyone in the state, and this is what it is. So if there's ever any way that we can contribute to your efforts in communicating this information, please let us know. Even if that's just you're having a district bar meeting in February and you want somebody from staff to come out there or appear by video conference, whatever it is, we are ready and willing to help out.
That's exactly the plug that I was trying to put in. So I want to echo and encourage you all to get that information out, because I know some of us know better than others and have heard more than others about some of the gripes and feelings that people have being targeted in smaller counties and certain groups of people and all of that good stuff. So it'd be really good to let people know that that's not the case, and we really want to educate them in the best way. Yes.
I was going to share, I think Ann left the room, but my office was audited 3 years ago and we were terrified. And Ann came and she was so kind and so approachable. And I mean, she was great. We had a few things that we had to work on, but it was a much better experience than I thought it was going to be. I think I'm still thinking of the old Bruno days.
Nice guy too.
Yes, Bruno was nice. He just sounded
He was nicer after your audit than before your audit.
Has the bar hired a new field auditor?
What's that?
Have you hired a new field auditor?
No. So our field auditor had a better career opportunity, and she took that opportunity. So we are searching for a new field auditor. If anybody knows someone who is very detail-oriented, likes looking at trust accounts, and doesn't mind driving around the state for kicks, a bunch of lawyers, please let us know or tell them to go check out.
That description got me. The more you kept talking.
I was scheduled for an audit before I was on the council, and then I got a call. We were all prepared, and then I got a call that she left, so that's why.
Yes.
I knew when.
You said,
I don't know, I was kind of ready, you know. It's gonna happen anyway, right?
All right, so we'll move, did I see somebody else? Okay. Report on ethics phone calls.
Yeah, so for the new people, one of the things that Nicole and I do is man the ethics hotline, as it's sort of called. Lawyers can call us or email us with ethics inquiries, and we answer them. So we keep track of how many we do each quarter. During the past quarter, we answered 780 ethics inquiries, and that's a little bit lower than usual. And all I can think of is that the way the vacation days fell in December, I think the majority of lawyers took off the second half of December, and so that's why I think it's a little bit lower. But I also try to let you know what the most frequent questions are, and the top 4 for the past quarter were conflicts, which is always number 1. We always get the most conflict questions. Advertising, confidentiality, and fees. And they kind of rotate around, but conflicts is always number 1.
Any questions? Any questions from anyone? All right. CLE, report on CLE ethics presentations during the prior quarter, which you touched on just a little bit.
Yes, just a little bit. So you know we're ready to go. If you need us to do a CLE hour, what have you, staff did 9 different presentations over the past quarter on a variety of topics, but I won't repeat myself. We are ready if you need us.
All right, so now we'll move to our pending inquiries, and I just want to let you all, the folks that are new on the committee, the materials that you saw in the short amount of pages that you saw is not typical, so don't get used to that. But we do appreciate those folks that are working in these subcommittees. You will see that is where the work really gets done. And so with that said, we'll inquiry of Savage. Is the first one.
So that's me. This is an inquiry that deals with the notice requirements that a law firm is required to give when one of their associates leaves the firm and probably goes to a new law firm. And the facts that we were presented with was a departing lawyer was employed by a law firm. The departing lawyer had decided to terminate his employment and begin practicing with another law practice. The departing lawyer requested contact information for his clients so that he could give clients notice of the change in employment. And his law firm maintains that there is no ethical requirement to notify any of the law firm's clients, and that the lawyer is not entitled to the client's contact information. So that was the fact scenario that we started with. We worked on this opinion for a while. It's a fairly long opinion. It has 8 inquiries. We have discussed these inquiries at previous committee meetings, and the first 7 inquiries are pretty not controversial. We got through those okay. And at the last meeting, the only inquiry that we discussed was inquiry number 8. And the question there was whether the law firm is required to give the departing lawyer a list of all of his former clients. So current clients, that was pretty clear cut. They had to give a list of the current clients. But this inquiry number 8 has to deal with the former clients, and there was a lot of discussion about that, and we ultimately concluded during the discussion at the last meeting that the law firm is required to give the departing lawyer a list of the former clients, and we were tasked with kind of editing the answer to opinion 8 to reflect that decision, and that's what we did, and that's included in the agenda. Opinion number 8, like I said, it says, is the law firm required to give the departing lawyer a list of his former clients? The opinion says yes, they are required to make a reasonable effort to do that. The reasoning is that both the law firm and the departing lawyer have an obligation to protect their clients' interests, and they need to cooperate during the transition to ensure that everybody's aware of potential conflicts. The rules of professional conduct already require lawyers to adopt conflict checking procedures, and the rules already allow lawyers to disclose information necessary to detect conflicts when lawyers change firms. a necessary component of any conflict checking procedure is going to be a list of all current and former clients. And the opinion concludes that because there's already this existing requirement, it is reasonable to require the law firm to provide the departing lawyer with the list that they're probably already maintaining. The opinion notes that law firms can provide limited information such as client names and the general nature of the representation without disclosing sensitive details. The opinion points out that providing the departing lawyer with this list will make it possible for the lawyer's new firm to identify conflicts and to implement screening procedures in a timely manner so that the entire firm is not disqualified. It concludes that refusing to provide a list of former clients to a departing lawyer could potentially harm the interests of former clients, and it could result in exposing the new firm to conflict-related issues that could lead to the entire firm being disqualified.
Okay, thank you so much, Suzanne. Craig.
Right
There
here.
you are.
Really, we were tasked with making some minor language tweaks, and I think those are all incorporated, and Suzanne's done a great job of identifying those. We moved quickly as a committee, and as you know, we got 7/8 of it done before our last meeting. We actually offered up what we call an alternative to what's in here, which had more limited requirements for disclosure, but I think this one is much more robust. I think it's in keeping with what is going to be something very different for people much younger than me, where you're going to have more than one job probably. I'm a dinosaur. I've only been at one law firm, and that's going to become, I think, increasingly rare. Just for the record, though, I'll say that Warren Savage is the fellow, in the inquiry of Savage, and he and I talked earlier this month, and I said, well, Warren, what are you going to do now that you're not part of this subcommittee and you're not really a full counselor anymore? He goes, well, Craig, get ready, because I'm going to send you some more inquiries.
All right, thank you. Is there any other subcommittee members want to speak on this as a part of this report? Okay. Y'all done a lot of good work. We appreciate y'all. I'll take a motion if you, or anybody else. Yes.
I have one question I want to, I'm not sure, maybe I've missed it in the proposed opinion, but with regard to the list, I completely understand the idea of the list. But what other information has to go along with the list, such as the general nature of the representation? Is that included in this somewhere? At the end of the inquiry number 8, the discussion says that law firms can provide limited information such as the general nature of representation. It doesn't say you have to. And I'm wondering if that's not essential information to have to determine whether you've got a conflict. I mean, just knowing that you've represented or your firm has represented someone in the past without knowing what the matter was about doesn't necessarily help you work through a conflict. So I felt like that might be something that we might want to talk about.
I see what you're saying. The way that the opinion was written was kind of describing that you only had to provide that amount, and that's why issues of confidentiality are not so paramount. But I don't know, is that something that could be changed with making it a mandatory sentence? Is that what you're thinking, or?
It is. Because getting the list may not tell you everything you need to know is my.
Right.
I would think that is kind of what the next step might be, though, John, because if you've got a robust collections practice, let's say, and you've got a ton of clients, that's an undertaking to provide some little narrative about each. But if there's one client that pops up as a potential problem, I could see us saying, well, you need to probably disclose a little bit more under Rule 1.6b8 to be able to complete the conflicts check and resolve whatever issues there are.
I mean, we could change it. It says law firms can provide limited, law firms should provide limited, with that.
Maybe can and should. That's what I'm looking at. They can, but they also should provide some limited amount of information so you know.
My thought is, I'm sorry. My thought is the burden's on the new lawyer and the lawyer in his new firm. So when the name pops up, then they better find out. So the name is really all they need at square one. Then the burden's on them to find out what's going on. So I would oppose changing the rule from what you've written.
We could in there in a comment in the discussion of what
Yeah, there is,
another
actually,
rule?
you're right.
Can't we just refer to that?
I think that
Or
might,
do a footnote that says
yes, it is discussed in the comments under
comment
1.6.
under 1.6 that you,
I don't have that with me. Anybody look at that? This is what happens when we don't have payment.
Anybody else have any comments, questions?
I would like to get this out there.
Right. Are we ready to move on it
Or do we need to?
pending this, information? Y'all wanna wait for a second? I think shall, it should be, lawyer should, or shall provide anything.
Suzanne, are you all thinking of just referencing the comments, comment
Yes.
17, I think, in 1.6?
Yeah, it's 17 and 18.
Yeah,
It's 17 and 18.
17.
I don't know if you need 18, but it's
Yeah.
17.
that's why
So just reference
I
it.
just reference that.
Would that satisfy you, John?
It would.
Okay. Y'all, can that be a tweak that we can do and then publish, is that?
Do we have a motion to publish?
So move.
All right, I have a motion to publish, do I have a second?
Second.
All right, I have a motion, and a proper motion and second to publish. Any discussion?
Can I clarify?
Yes.
It's a motion to publish with the inclusion of a reference to comments 17 and 18 of Rule 1.6. All right.
Yes, yep.
Hey, Judge,
Yes, sir.
is it,
Go on.
can, should, shall, what's that word that's going to be in there? I know that it was can initially, somebody said should, you said shall, what are we, what's the word we're going to use?
I believe it's going to remain can, but the context of the sentence is that lawyers can provide this limited information without disclosing sensitive details. It was kind of an illustration of the, I guess really supporting the expectation that the rules say, law firm, you need to give information. So earlier in the opinion, that inquiry, or excuse me, in the actual opinion, it states that lawyers are required to engage in these conflict checking systems, so they need to share. I think that's or share this type of information. So the word can, as used in that sentence, I think is okay, and referencing the comment as we've discussed would clarify, kind of bring about that, we really are talking about a requirement of lawyers to engage in effective conflict checking systems. And yes, lawyers have the ability to share this information without disclosing sensitive information,
And so if my firm decided I don't want to share the nature of the representation, I haven't violated the rules, so I said I'm going to be hauled in front of the rules committee. If it says shall, and I don't, I'm in front of the rules. What are we doing?
I think the opinion, maybe Ellen, I don't want to keep on talking. I think the opinion does put that requirement on.
It already has the requirement that you're speaking of, so yes, you would be in violation if you don't.
I think what the sentence is saying is maybe it should say, as permitted by Rule 1.6.
Yeah.
That's what
Be
the reference to the
a lawyer can. In other words, that sentence is referring to the fact, I think, that
Yes.
the lawyer is permitted to without violating the rule.
The confidentiality.
Not that a lawyer can if they want to disclose it, because the opinion already says they gotta disclose it.
They have, the opinion already says that you have to disclose it.
Okay,
I think
as long as it's clear, because obviously what we do here can land folks in front of grievances, so.
Right.
All right, thanks.
All right. Any other discussion? All right, all those in favor of the motion to publish, please say aye. Aye. Any opposed? All right. That will be published. Next, inquiry of DRC, negotiating licensure, reporting capability during mediation.
So this is an ethics opinion that we prepared as a result of an inquiry that we got from the Dispute Resolution Commission. I'll just briefly give the facts. We've been living with this opinion for a long time, but in the facts, a lawyer mediator is mediating a case where the parties are represented by counsel. There was a lot of acrimony apparently, and in the settlement agreement, the lawyers and their clients wanted to include, or the lawyers wanted to include in the settlement agreement that no party or no lawyer would report one of the lawyers to the North Carolina State Bar, which is against our rules. We have an ethics opinion that says you can't negotiate away the filing of agreements. And so the question in the inquiry is, what are the duties of the lawyer mediator? And the opinion concludes that the lawyer mediator can't participate in that. They can't facilitate lawyers violating the rules of professional conduct. So we prepared this proposed opinion. The DRC questioned one of the things about whether or not the lawyer mediator must withdraw from the mediation if the lawyers want to participate in a settlement negotiating term where it would violate the rules. And so they wanted to prepare their own advisory opinion that would require the lawyer mediator to withdraw. So we tabled our opinion pending the outcome of their advisory opinion. The advisory opinion is in your materials. It is pretty much in line with our opinion. The only thing that staff disagrees with, and I'm not sure that we should fight about it, but the DRC believes that the lawyer mediator telling the lawyers this term violates the rule of professional conduct is legal advice. And we don't agree with that. But otherwise, the opinion is in line. We just recently learned that the DRC is waiting on our subcommittee to comment on their advisory opinion. And so we need to do that. So Britt has already sent out a doodle poll to the members of the committee so that we can try to get a subcommittee in the next 2 weeks so that we can comment on their advisory opinion, and then they'll go forward, adopt their opinion, and then we'll be able to publish our opinion.
Thank you, Nicole.
So yes, I recommend it stay in subcommittee so that we can look at their advisory opinion and issue any comments that we may have.
All right, David Allen or any others from the subcommittee want to comment any further?
Yeah, when this first came up, we thought it was good to defer, at least, or to wait and see what the DRC did on this. Give them a chance to weigh in. They asked for that, and we said we would defer until this meeting to let them get their act together and do what they've done. Now, they published this for their comments, and they want us to comment about that. I think there's clearly some disagreement about the question Nicole raised about whether this is legal advice or not. In the rules, it's not legal advice. Read it yourself. The second part is about the withdrawal. We did not, I think the subcommittee didn't think that there was a need to withdraw here. You just say, I can't do this. You can't make me do something you don't want to do. But anyway, those were issues we thought the DRC should probably deal with. I think we ought to respect their request, postpone until April, and let them get this. We asked them to expedite their stuff. We thought we'd be able to deal with it today, by January. And we didn't realize that they were sort of also deferring to us. So I think we ought to take another, I hate to say it, take another couple of months and come back and make our final decision on what we do in April. That's my recommendation, is that we continue the subcommittee until April back here.
Yes, sir. Any other subcommittee members? Who wants to speak on that? All right. Mr. Allen, I have a motion to send this back to
I
subcommittee.
that we put the matter back on the agenda for April and have a subcommittee meeting in the interim.
Second, I have a motion and a second to send this, return this to subcommittee. Any discussion, any further discussion? All those in favor, please say aye. Aye. Any opposed? All right, back to subcommittee. Thank you all. Next, proposed 2024 FEO2, withholding criminal discovery in district court. Suzanne.
This is an inquiry that has to do with criminal law, and the inquiry involves conditional plea offers and whether they're permissible under rules of professional conduct. This inquiry involves a criminal case in district court where the defendant's facing a Class H felony drug charge. The DA offers the defendant a deal. If the defendant pleads guilty to a Class I felony, the DA will suggest probation. But the defendant wants to pursue a misdemeanor offer, and his defense counsel sends the DA a discovery request. At that point, because under the current legislation, there's no legal right to discovery in district court criminal cases, the DA responds and says, if you want that discovery, I'm going to withdraw the plea offer and I'm going to seek a conviction on the Class H felony and seek the maximum punishment. The issue is whether this type of conditional plea offer violates the rules of professional conduct. A proposed ethics opinion was published for comment, and that proposed opinion provided that under the law as it is now and under the ethics rules, this type of conditional plea offer is permissible. However, the DA can only make this offer if the DA is confident that he's complied with his professional responsibilities set out in Rule 3.8. And that 3.8 requires DAs to refrain from prosecuting a charge that is not secured by probable cause, and requires the DA to provide defense counsel with any evidence that tends to negate or mitigate the defendant's guilt. The opinion concluded that if the DA had determined that the charge was supported by probable cause and that he had given defense counsel all the exculpatory evidence they were entitled to, the DA it's within the DA's discretion to offer the conditional plea offer. The second inquiry looked at the responsibilities of the defense lawyer, and it said it was permissible for the defense lawyer to offer this plea offer to his client as long as he explained to his client that there might be other information in discovery that they're not aware of. And at that point, it's up to the defendant to decide if he wants to take the plea offer. After publication, we got several critical comments. Concerns were raised. First, nobody really said that the opinion was wrong under the law or the ethics rules, but concerns were raised about the potential for prioritizing court efficiency over defendants' constitutional rights, about whether defense counsel could adequately advise their clients without reviewing all discovery materials, about how it would be possible for the defense counsel and the defendant to sign the plea transcript if they didn't have all the discovery, and there was concern that these conditional plea offers could lead to injustices and claims of ineffective assistance of counsel. So the inquiry was sent to the subcommittee to look at all those comments. We invited all the individuals who had commented to participate in the subcommittee meeting, and we did have several people that joined. We had representatives from the North Carolina Advocates for Justice, the Forsyth County Public Defender's Office, the Wake County Public Defender's Office, and a criminal defense attorney. At the subcommittee meeting, the majority of subcommittee members agreed with the critical comments. Some members also felt that the discovery issue itself was too complex and too intertwined with the legislative matters for us to opine on. They also expressed concern about the optics of the ethics committee adopting an opinion, specifically allowing prosecutors to make these types of conditional pleas. One subcommittee member supported adopting the opinion as written. He noted that the opinion is correct under the law and the ethics rules. He noted that such plea deals are often offered for good reasons, such as court expediency, to protect confidential informants, and because sometimes they can be in the best interest of the defendant. He argued, this subcommittee member argued, that the legislature should address any problems that came up, and that adopting the opinion might actually prompt legislative reform. The guests expressed a general concern that the opinion was unnecessary and that a broad application of the original opinion could have unintended negative consequences. Basically, they felt that it would do more harm than good. Ultimately, the subcommittee voted 3-1 to recommend withdrawing the opinion and not issue any formal opinion.
All right.
I think the consensus in the committee kind of boiled down to this. You know, when we issue formal ethics opinions, we're wanting to provide guidance where none exists in the rule, where we're filling in gaps. And this question to me sounded kind of loaded and put the bar on the defensive, to have to defend a practice that is legally correct but optically poor. I don't want to, we can't override, we can't find any legal justification for overriding precedent or statute. This is a practice that occurs regularly and is often to the benefit of defendants, as several defense attorneys commented. Suzanne, I want to ask you, will we provide, or will you provide any written or oral opinion to this attorney?
We can, one thing the subcommittee discussed is still providing the inquiring lawyer with an unpublished, would that be an ethics decision or a?
Yeah, it would be kind of an advisory, that would primarily focus on, what is in the opinion is, inquiry and opinion number 2. Because that was one that was focused on the defendant. And that was who asked the question, or not the defendant, excuse me, defense counsel.
Right.
Defense counsel is who asked the question, am I allowed to present this plea offer to my client under these circumstances? And, we can provide that answer. We felt in putting this before the committee in the formal opinion, you can't really address the second part without addressing the first part. And I think that's where the more harmful than helpful started to come about. So yeah, we could provide the inquiring attorney with essentially what we have in inquiry and opinion number 2 about their ability to present this plea offer upon communicating with their client about just what's going on. So, and we will be able to use that for any other person that calls about that particular question. But we could not opine, we never give one lawyer an opinion on the conduct of another lawyer, because that's why we wouldn't talk about, whether or not it's okay for the DA to do that in the first place.
And a formal ethics opinion would do just that.
Correct.
Right? You're broadcasting, publishing. And I think that's gonna open the door to a lot more inquiries and a lot of confusion about how plea bargaining happens. And that concerns me. I mean, I think one example too, I mean, we're gonna get an inquiry that, from a defense lawyer that says the district attorney told me that if I don't accept the plea to second-degree murder, we're gonna seek the death penalty, your client's gonna fry. And then you get a ethics inquiry that says, is it proper for a prosecutor to threaten to kill my client? And then we put out an opinion that says, in the context of capital litigation, yes, this is permissible, and the optics are awful, right? We're threatening to kill people. And I just don't think we need to get involved in that process. So I would support withdrawing this opinion.
Okay, so you're in agreement with that, but my question for you is, are you in agreement with giving that information, the inquiry information to this lawyer that requested or made this inquiry?
It's legally correct, but I don't think it should be published.
Right, okay, I was just.
Hello, I'm sorry if anyone can hear me. We just lost all sound on the Zoom.
I think we've lost them.
Yeah, I don't see them anymore.
You're right. Did we lose the connection with them?
That was the only thing, this moment was the only thing I was here for.
Yeah, this is my thing too.
I mean, come on, Eddie and I.
They're freezing you out.
Yeah, they don't want to hear what we have to say.
Here, I'll text Brian.
Okay, that'd be great. Yeah. He said, we've heard too much about this.
Okay. Do you think it's our link, you guys, or did they just disconnect us?
It looked like I saw something pop up that said the whoever was hosting changed, and I wonder if when that happened, somehow we lost the link. I don't know whether we need to like log out and try logging back in.
Well, what I really think we should do is rewrite all the opinions just between us real quick. And Tara, what do you want it to say? I mean, are you good with it?
Yeah, I wanted to say those dang DAs can't ever do that.
Okay, so we're
no,
gonna make
this is crazy, but I'm glad I'm not the only one on the Zoom. I would be upset.
I turned my video off for a minute. Okay, let's see. Yoo-hoo, Brian, I'm about to call him. He'll be unhappy if I just call him in the middle of the meeting, but I will. Hold on. Does anyone see, did we get any emails?
Can we see the live YouTube broadcast? Is that might be that we could?
Oh, he says that, the internet went out. Oops.
Well.
Oh, well.
Oh, okay.
Sounds like we're off the hook.
Yeah, it sounds like it's not us. And so we're going to say that we think prosecutors can't do that. Otherwise, we're out. All right. So he's trying to get it back on.
So we should stay on, Heidi, and just wait.
Yeah, I think it's an internet problem, not like a link problem. So I
Okay.
assume once they regain the internet, we will regain access.
Okay.
Poor Brian.
I know.
It's so nice to have this option. I'm hoping they get us back.
I was hoping, how come you guys like have all your windows closed? I want to see your snow. I love snow.
It is absolutely amazing here where Martin and I are. We haven't gotten a real snow in like 10, 12 years.
Well, nor have we. We live in Raleigh. I mean,
yeah. But this is like, I mean, I got 6 inches at my house.
Oh,
6 inches.
man.
Yeah.
Crazy.
Oh,
there's Brian. He's trying. I think I can. Hey. Can you guys hear us again?
Your audio's off.
Oh, Brian's got his sound off.
Okay.
They're back.
Okay.
Thanks, guys. We made a bunch of changes to the rules while we were offline.
We all approved them.
Yep, so we hope that's okay.
Did that answer?
Yes, it did.
All right.
Thank you. That was a good answer.
Thank you. Yes.
Before we vote on that motion, can we call this lawyer and tell him, give him the advice as if he called into the hotline, as opposed to sending him a letter that he is going to scan and email to all of his friends?
I mean, we run into that all the time.
Also, I was going to say, sorry to interrupt. This is Tara Gore on Zoom. I feel like since the proposed opinion was already out there, I mean, that's something so many people have already accessed, and it's been all around the defense bar, on all the listservs, every public defender's office. So I feel like it's out there at this point.
Yes.
I have another question, or not to be pedantic, but folks across the hallway might want to know that we made this decision too, because this could be easily one where people say, okay, they don't want to opine on it, I'm going to go ahead and force the issue and file a grievance. And I think we need to have some level of explanation. Now, that may not be realistic. I don't know how it's handled internally, but I could see someone saying, well, I don't think that resolves the issue. By the way, I'm in favor of doing what we're recommending. I'm not trying to throw a wrench in things, but I do think if we're preserving issues here, maybe have something in case that comes down the pipe. I hope it doesn't.
Yeah, and that's, I think I'll just say that there's, while the content of our ethics advice is confidential, I think our ethics staff is, we get consulted by the grievance folks when they're saying, we just saw this, and we don't know what to do with this. It's, and especially if somebody actually has a grievance that gets filed against them, it's nice to, I'll just say this, I feel comforted, having been on both sides of both the grievance side and the ethics side, that our stuff remains entirely walled off. Grievance doesn't have any access to it. That said, when they run into issues and they have questions about ethics, then oftentimes I'll get a call. I think Nicole will get a call, Suzanne will get a call. So, but communicating this particular thing, we'll just say we'll keep our ears open if there's some sort of opportunity to address this with them, so they know what our opinion is.
Yes. I'm sorry, I said, Warren, I was coming to you next. I did.
That's all I was gonna say in response to what Gina said. If I'm the lawyer, the criminal defense lawyer, I want this in writing.
Oh, yeah.
To rely
No,
on.
I get it.
If my client later on says I gave him bad advice, that'd be nice to say.
No, I get it. I just don't want anybody to be naive enough to think that the information is gonna stay with that one individual. It's not.
No, I-
Yes, that's exactly what I was.
It's one thing
It's
to
already
say-
been out there too.
It's one thing to say, I talked to Nicole and she said blah, 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 because I do that all the time. It's another thing to say, here's what the bar sent me,
Yeah,
to
yeah.
all the criminal defense lawyers that you know.
Yeah, well, and that's where, honestly, I feel very comfortable with that second part of the opinion, saying, defense lawyer, you've been presented with this scenario, looking at your professional responsibility, you inform your client, listen, this is the legal parameters that we're dealing with, so I haven't been able to look at everything. However, I can say that, presuming they do have the evidence, this is actually a very good outcome for your case. And that, really what our advice does is allows the defense lawyer to go forward with that plea if that defense lawyer, in his or her best judgment, thinks this truly is the best outcome for my client. As long as that's explained, I may not have seen the full file, but I, lawyer, can still achieve what I think might be the best outcome for my client. And that part of the opinion, I feel very comfortable with.
That's all he gets, that part two?
Yes,
Right.
yes.
So it just, I think that's the key point, that is to the defense attorney and not information going to a prosecutor who may be involved in this. And we're saying, it's okay what you're doing.
Right.
It should be circulated, because you're gonna be relieving a lot of stress because there are people out there who have wondered if this is appropriate, and it's, I think, a service to actually let it circulate.
Well, I mean, I'll tell you, that was one of the things we were really struggling with, because we could have focused it entirely on that second part, but then the question naturally comes up, but is it okay for the ADA to even offer this in the first place?
Right.
And that's where we get into that tough spot, so, yeah, I'm not sure exactly how to best do that.
I feel really good that the way that the information has gotten out there already and been shared, it's out there, and folks know.
Can I clarify my motion as well? Further, if it helps?
Yes.
That my motion would be that we withdraw our opinion, and, state that our opinion is being withdrawn as to part one. Part two, an advisory opinion be issued to the attorney who had the inquiry,
I can draft that up.
right? And that way we're dealing with.
Right.
Part two, the defense attorney is getting their answer, as they should.
Right.
Which says, hey, you're coming to your client with the information that you've been given. And if the DA says this to you, whether it's right, wrong, ugly, good, bad, whatever, that's not on you, making sure that you inform your client as you're required to do, and your client make that decision, and y'all make a strategic decision based upon the information that's been provided to you. That's all that would be said pretty much in number two, right? And then number one, our hands are off of it because it's already dealt in legislative, as a legislative issue. We're not getting into it, but we're saying that we're withdrawing part one and we're addressing part two in that advisory opinion.
Yep,
that's it. That'd be my motion.
So we're withdrawing it off to, motion, proper, any discussion?
Motion, but I got a question. So when I go back.
So we have a motion and a proper second, any discussion?
So when I go back to, my local bar and explain this to them, I could just give them part two and say, this is the, and then explain that we withdrew the, and that way they'll know.
Well, I want to make sure we're clear though, we are withdrawing the entire inquiry, and we're giving the defense attorney who made the inquiry
That we're giving.
the answer to his
The
question.
answer to the person who inquired.
Right.
And this is the answer we're getting.
Correct.
Can I do that?
Yes.
Right, if it would be helpful, since this, these ethics advisory opinions, they are informal, and they are to the lawyer, and therefore should remain confidential. They do get reviewed by the ethics committee though, as they are kind of officially put forth, as the answer from the ethics committee. I don't know if it would be improper to circulate it to the ethics committee after this meeting, or just to wait till April.
Just number 2?
Yeah, just the number 2. I mean, it's based, I guess everybody already has. I'm just saying that.
Didn't we do that already?
Yeah,
Yeah,
it's
they were-
just gonna be number 2. Nothing's gonna change from number 2, so.
I mean,
All right, let me withdraw my
Right.
thoughts.
We're complicated, we're already there.
We're good.
All right, all those in favor to withdrawing the inquiry, please say aye. Aye. Any opposed, nay? All right, thank you. Inquiry agrees, client consent to annual rate increase.
Yes, so this is, oh, yes,
Conflict,
oh, yes.
Okay.
gotta go.
You scared me.
Wait, Gina,
Get me after this is over, though, y'all left me out there last time.
okay. Sorry, Gina, do you have guests here with you?
I do have
Can you
guests.
introduce your
I'm very
guests?
proud about my guests. This is my daughter Adele. Who's a senior at Chapel Hill and going to law school, we don't know where yet. And this is her roommate Lindsay, who's also a senior at Chapel Hill, going to law school, don't know where yet. So I was like, y'all can figure out how it works by visiting. So there's that.
Do you still want to go to law school after sitting in?
We'll make sure to come get you.
Yes.
Thank you.
All right, so this was an inquiry that was sent over by the grievance committee. As I think I've said to both veteran members and our new members, sometimes the grievance committee runs into issues that really just make their brains hurt, and so they send them to the smart people to get it figured out. So that's where we're at. This one concerns a fee agreement provision that basically allows for a law firm to increase the rate of the fee, the hourly fee, I guess you could say somewhat unconditionally. It just says that the client is agreeing that the law firm will review their annual rates, or their hourly rates on an annual basis, and the client will be notified of any increase in the fee in the next billing cycle when the rate is imposed. And the effect of this was essentially client received a bill about a year into the representation, and the rate had increased, and that rate had already been imposed on the prior month's work. And so client, of course, is left to pay that bill at the higher rate without really any sort of notice. And so the question came up just as to whether or not that type of provision is permissible, or if there is some sort of maybe alternative provision that would permit a firm or a lawyer to increase their rate at some periodic basis, because there is the practical reality of some cases last for years. And when a case lasts for 3 years, then sometimes costs go up and rates do get increased. And of course, our rules have this a comment, particularly Rule 1.5 dealing with fees, has a comment that is unique to North Carolina. It is not in the model rules of professional conduct, but it basically states that lawyers can seek to renegotiate a fee agreement, but they can't threaten to abandon the client to coerce a higher fee rate or hourly rate. So the question then again is just, is this type of provision permissible? And if this isn't permissible, what type of provision might be permissible? The subcommittee met just last week for the first time to start discussing this. I think that the proposed opinion right now or the original draft opinion was that the provision as drafted was improper, but I think the subcommittee was really focusing on the requirement for notice, that the thing that was really missing from this particular situation was notice for the client to be able to respond before any sort of fee increase is imposed. And of course, there's the general rule that any fee increase cannot be clearly excessive. There was some discussion in the subcommittee of should we actually put a number on that, and what would be the cap? What would be clearly excessive? And the subcommittee came to the conclusion that type of thing is that type of number really is impractical, because whether something is or is not clearly excessive is largely dependent upon the circumstances. It depends upon the representation, the nature of the increase, the reason for the increase, things of that nature. So that is best left to kind of the broader judgment of the lawyer to determine what is and is not clearly excessive. So the opinion, I guess, is still being edited and we're going to be redrafting and meeting this next quarter. But Davis is chairing that, I'll be happy to defer to him on any other comments.
Yeah, I think that Brian nailed it. I think that we, as a subcommittee, everyone agreed that the actions that were summarized in the fact pattern were not okay. That they quickly got to the crux of the issue, which was the sufficiency of the notice of the increase of the rates. Due to the lack of sufficiency of notice, it created a scenario where now this lawyer's threatening to abandon their client, which is a bad situation to be in. We agreed that we didn't want to really get into the clearly excessive and set a specific standard for that, other than just to say, hey, you need to make sure you get notice and make sure it's not clearly excessive. And so I think Brian's gonna work on the opinion a little bit. We're gonna meet again. And so our recommendation is to keep it subcommittee.
All right, yes.
I just had an observation and then a question. I primarily work for companies, big companies. They tend to have in-house departments of lawyers that are bigger than my firm, which is over 100 people. They give us terms. They might entertain a tweak. They tell us what our rates will be. We talk about it, but point being, the terms don't cover some of what this response is looking for. They just don't. And so I wanted to ask, is there a way to provide some like big client feedback to the subcommittee so you can take that into account? I don't mean to chew up a ton of time in this meeting to do it. I feel like it might be not the norm.
Yeah.
Does that make sense?
Yeah, absolutely.
So is it a scenario where your client is dictating the terms rather than lawyers dictating the terms?
Well, their lawyers,
Oh, their
in-house
lawyers.
lawyers, are writing the terms and pushing them to us, yeah. I frame it that way because it sounds like the fact pattern is not that. That the client is a human or maybe a small business without an in-house lawyer. And I'm confident none of my real-world scenarios, if anyone's being taken advantage of, it's definitely me. Technically, I think some of the way they're going about it and writing into their terms would happen to violate this, and that struck me as an unintended consequence, and I don't want to be in front of grievance.
Right.
So is there a way to give a little bit of that feedback that would be constructive?
I think we discussed the fact that we want to make sure that this opinion fits all, all range of folks, and we would certainly invite you, and we'll let you know when we have a subcommittee meeting, because I think we'd love to have your input, and I think the biggest issue is just, to make sure that the client knows, what's going on, and that everybody's kind of on the same page when in terms of these increases.
Yeah, that makes sense. Okay, thank you.
Got you on that, sir? Yes, sir.
I do family law primarily, and I understand the notice is an important aspect of this, and there's another aspect that is very important is that many of the clients I have really struggle to pay the fees in the first place. And the one thing that they never want to have happen is lose the lawyer. And so there's sort of inequality of bargaining positions somewhat, because there's really a strong pressure on the client's part to not have to change the lawyers. So, for example, we can play into the negotiations standpoint. Whatever we do with this, we need to keep that.
Absolutely.
Can he repeat that? I couldn't hear because there's a lot of other conversations. He's talking kind of soft.
He was saying that that a lot of times clients have difficulty paying the rates that are in agreement. Sometimes there's an issue about, if I'm not misunderstanding, you're basically saying that you don't want to create an opinion where it says that you can't withdraw from some sort of representation from, if there's a lack of ability.
That situation, at the same time, with clients, sometimes with these hard cases, the worst thing that can happen is they have to change lawyers. You see, so they're not in a position that they have much bargaining position if they can't afford or just don't think it's fair to increase the rates. But they've got a very strong pressure to not have to change lawyers because financially it's punitive. They're essentially going to have to incur more fees to get another lawyer at his fees. So it's a difficult situation for those clients to be in. And typically, and every practice is different. I'm in Concord, so it's a different sort of economy, I guess, of the practice there. But we rarely will increase rates for an existing case. Generally, we will keep the rate through to the conclusion of the case. That's not always possible. If the case is going on for 5 years, that's a different thing. In a case that goes on for a year or 2 years, it's just not a hardship on the firm to just maintain the rates. And then that way there's no issue.
I agree, Jenny, with what you're saying. Oh, I did.
Go ahead.
I'm sorry. I think the timing of the state proceedings makes a substantial difference. If you've been in litigation for 3 years and you're basically mediation, that's different to me than maybe a pleading, maybe responsive. That's less problematic, but I think it's a factor that we should consider as opposed to just kind of these rules or guidance for that. And it's one of those type of deals, because it's what happens on the other end. The other uneven aspect of these things is where they run out of money, and we're at that stage of the case, and we're doing it basically.
It is a tremendous hardship on these clients to change lawyers. Okay, so there's a real, I guess, pressure on their part not to have to change. And that's a little bit of an unequal bargaining position when it comes to increasing those.
I think this is a prime example of why we do this work, which is to protect the public from the bad acts or, negative actions of our lawyers. So what you said is in regards to, it puts them in a very bad negotiation position.
Yeah, and Bill, I would say one of the things that somebody was really focusing on was, when does the notice have to be provided in a way that gives the client some reasonable opportunity to make a decision. Clearly imposing something like a 100% increase on your fee, that's gonna be clearly excessive. But if you have to increase after 2 years by 5%, if you've told folks at the outset of the representation, my fees may increase, but I'm going to give you, X amount of 60 days notice, whatever it is, and an opportunity to discuss, something like that. I mean, it's hard to put exact numbers on what these timeframes need to be. But the big principle just being that if the lawyer kind of gives, really the lawyer and the client enter into this agreement, eyes wide open, they know what's going to happen, and then there's an opportunity for the client, like you said, to make an informed decision about the representation. That would hopefully strike that balance, because like we were just saying, if the client runs out of money, you have an opportunity. It's ethical for a lawyer to withdraw for a client failing to meet one obligations of representation. And so this feels like it's trying to balance that tension and respect the rights, the opportunities, the preferences of both sides here. So we're keenly aware of that, and I think it's a very, very good point.
All right, any other questions, comments? All right, do I have a motion to send this back to subcommittee?
Send it back to subcommittee.
Thank you.
Second.
I have a motion and a second to return this to subcommittee. Any further discussion? All those in favor, please say aye. Aye. Any opposed? All right, back to subcommittee. And now we have a new inquiry of Kent, Public Defender Offices in a multi-county district. Go.
Yes, this proposed opinion rules that in each office in a multi-county public defender district may be treated as a separate law firm, and therefore may be able to and can handle conflict cases involving co-defendants or when the parties are adverse to each other. So you might have a situation where it is one office represents a defendant, and then another office may represent a defendant in an unrelated matter, but who is a witness to the first defendant's case. So conflict of interest. In these multi-county districts, some of them, the public defender, there is a PD office with 2 or more counties, and each office is separately staffed. When the PD office has a conflict due to defendant to oppose, or defendant client is a prosecuting witness, as I said, in an unrelated matter. There are, as you know, a lot of North Carolina counties are desert counties, and so there are not enough or insufficient number of private lawyers who can take on these conflict cases. So the question in the opinion is, can the public defender offices with the same multi-county defender district handle conflict cases involving co-defendants or parties with adverse interest without violating the rules of professional conduct? The opinion relies on Rule 1.11, which is the conflict rule that applies to government lawyers, that requires those lawyers to avoid conflicts of interest as governed by Rule 1.7, concurrent clients, and 1.9, duties to a former client. The opinion also relies on RPC 55, which is an older opinion, that allows the AG's office to operate, for the departments within the AG's office to operate as their own separate independent law firms for purposes of conflicts of interest. In that opinion, it explains basically that if we enforce the conflict rules strictly, then the AGs would not be able to do their job, because they have their statutory mandates of what they're, who they're supposed to represent. And so we likened it to the public defender's office, and found that the opinion provides that a strict application of the rules would be unreasonable under these circumstances, and refers back to the preamble where we have to apply the rules reasonably. This opinion distinguishes from RPC 65, in which those lawyers in the public defender's office, they were in the same office, and therefore they could not avoid conflicts of interest. But in this proposed opinion, the offices are in different counties, so there are separate offices, although they are in the same district. The proposed opinion provides that when the public defender's office has two locations, each office is its own firm, provided that each office operates independently with distinct leadership, they have separate staff, and they are physically located in different locations. The attorneys involved cannot have substantial or imputed knowledge of cases of the other office, and they must implement screening measures in order to protect confidential information.
All right, thank you, Nicole. We do have some folks that are listed there in parentheses as our proposed subcommittee members. So I'll go to Jay Moore first, and then Foster and Thomas. Eddie is online, I think.
Yes,
Yep.
Eddie's online.
So, anybody want to give any comments?
Well,
Kind of first thoughts?
I've already had one chief public defender who disagrees contacted me, so I don't think it's really as clear cut as it may seem. He represented to me that a lot of the chiefs just think it's not ethical to do that, and it creates problems, especially from the client standpoint. I mean, you have two lawyers, different counties, but same office, representing co-defendants, pointing the finger at each other. And, co-defendants are like, hey, they work together, they're in the same office. I mean, it's another one of these, the optics don't look right here. So, we're personal friends, and he knows I serve on this committee, so he just went ahead and reached out to me. So, I'll just pass on that.
Can I ask a question, Jay?
Sure.
Is that person in a county or district where there's a maybe not robust, but a healthy court-appointed list?
Yes, which makes a difference. And he talked about that too.
Yeah.
Yeah, yes.
All right, let's see.
Judge, can I ask?
Yes.
Oh, I'm sorry, go to the, I have a question and comment, but go to your subcommittee first, and then I'll follow up.
Thank you. I was, this is my area of the state, and the first district and the second district specifically are multi-county areas where this is a problem. And we're struggling with a real shortage of attorneys to handle these cases. And I think that's what kind of the impetus is when Bert inquired about this, was that fact. But I agree with Jay that there's some real traps here, and it could be a quagmire if you're not careful. So I think we need to take a close look at it. Equally, by bothersome is these single office public defender districts are having a lot of trouble. So I know that's not part of the inquiry, but it's part of the problem too.
Eddie, I know you're online. Did you want to chime in any?
No, I don't have much to add. I agree that, you know, we are experiencing a shortage of lawyers for the court-appointed list, but the optics of this is tough. Public defenders, we have difficult reputations sometimes with our clients. They don't pick us, they don't choose us at all. They get stuck with us, and sometimes it's good and sometimes it's bad, and you got to fight that, the optics of things. And so now this will throw in another thing that you have to fight, you know, in terms of, you know, representing clients. So I do appreciate Jay mentioning that, but no, I don't have anything else to add. I look forward to working on this committee.
All right, thank you, three, sir.
I have a question. Sorry, this is Tara Gore on the Zoom, if y'all can hear me. If does this change? My district is 3 counties. We just got a public defender last year, and so everybody's kind of still staffing and working out the kinks. Does this analysis change if, say, there's one very experienced prosecutor who's a floater, but other than that, there are 3 distinct offices? I just feel like that may be a more common thing, at least in the Southeast. I think Duplin, Sampson, Onslow, that district does it. Also Columbus, Brunswick, and Bladen. And I hope that the subcommittee will kind of factor that in to, if it's one person who works in all 3, 3 people who work in all 3, if everybody's distinctly separate, but sometimes there's one person who may cross over. I just feel like a line or two addressing that maybe would provide some guidance.
Yeah, that would create a conflict.
That would definitely be a conflict.
I think it would too. I just feel like some clarity there would help.
What the inquiry speaks about the person being in separate, distinct offices, even though there's but not one that would be a floater by what you're saying. Ramos.
Mike, did you have a comment? Mike Ramos?
All right.
So as a former public defender, oh man, this really troubles me. I get it, but you know, we were not multi-offices, but we were very close. We talked about cases all the time. I think this could be bad for office morale. So it concerns me. The other thing, I was just, some semantics I was a little troubled by. One of the conditions said that if you must have distinct leadership. They don't have distinct leadership. The chief public defender is the leader. So maybe just some wordsmithing with that about distinct office managers or distinct inter-office leadership.
Yeah, I think, you know, we're trying to look at this in a way that the ethics committee 30-some years ago looked at the attorney general's office, you know, and the reality of these types of kind of statutorily compelled representations. 2 agencies might go against each other. They're supposed to be represented by the AG's office, and how can you make that work? Understanding the rules of professional conduct are rules of reason, and the rules should not, I think, be so rigid as to get in the way of something like constitutionally guaranteed representation, but how do you do it in a way that preserves the integrity of the representation is, that to me, that's the real puzzle here. And writing an opinion that will apply to both multi-county and single county districts with all these different kind of circumstances is going to be tough. But it's an issue that we cannot ignore, it feels like.
We can't, especially with the creation of all these new public defender offices and the hope that we get more.
Yeah.
Having just recently been the chair of the IDS commission, that has been a great undertaking. So I think that it's gonna be a lot of work in this subcommittee. I would love for us to definitely invite the folks from IDS and some chief public defenders or some public defenders from these multi-districts. We have quite a few, so I think that their voice really needs to be there and hear from those folks who are actually there doing that type of work. Yes.
Yeah, so I don't know the on the ground of this type of scenario, so I hope someone will help me where I get this wrong. But what I do see this opinion relying heavily on is what we see in Rule 111 in terms of screening and independence and no subjective knowledge. And I wonder if the resources are in place or if there will be a need for resources in these offices to allow them to do this in a way that makes sense. I mean, if I'm gonna say, okay, I'm gonna let, because I'm from Winston, Womble Winston and Womble Raleigh be two separate firms. That's not what we're saying, I recognize that, but, you know, I don't have a lot of doubt they have the resources to make that happen technologically and otherwise, and independent leadership and all that, but I wonder if this is going to, if the resources exist enough to make compliance in this way realistic. I don't know that.
I can tell you the short answer is probably not.
Yes, and that's a problem.
The resources are already not there for us to have all the public defender offices that we would like to have.
Right, so this is gonna be a burden for them in that respect.
Plug for the legislature. More money.
Seems like on a Madam Chair, thanks.
City badge.
Flat revenue. The response is ask for things that don't require money this year.
Good luck on that.
Yes.
I mean, I think Professor Murphy highlights the question that's on my mind, which is if you do this robustly enough to make this possible, it may not be practical, but also the next inquiry is going to be, well, Womble Raleigh, Womble Winston, because they can effectively screen off whatever verbiage we choose to use. There'll be a great argument, and I think we have to be careful that we don't want that. There's a distinction, constitutionally created or statutorily created entities, I understand all that, but the logic that we're going to adopt if we go down this road is going to be tough to resist when some private firm comes doing it. And then there are other implications of that too. So we just have to keep a very close eye on the anti-competitive nature that might bring up to us as well. I'm concerned about opening the door, even a char on that.
Judge Lane has hand up.
He's a ladies first.
Thank you. I mean, I think the main thing is, and I love that it's going into committee and happy to assist in any way, but I think the biggest thing is that it says may. It's gonna be up to the chief public defender on whether or not they can do this or not. And it's whether or not we're gonna pigeonhole them and, you know, us getting into the weeds of their things and saying, yes, this is permissible if you can meet the rules of professional conduct and how you screen and how you do things. I mean, as far as the question was for this, I mean, I definitely understand concerns about firms and all that, but they need to inquire and we can deal with it. But we're talking about public, you know, government right now, which is why the AG's office was able to do it. And so I like already that it says may. It's not saying shall, can, you know, it's saying may. And so it's gonna be up to the public defenders to see what they can do.
So you'll learn that may change a whole lot by the time.
Oh, yeah, right.
It said may now.
We can turn to some of the big firm lawyers that are on this committee, on this ethics committee about screening, about Chinese walls and how that works. Because that's the only way that's going to work is if there are some really strict safeguards in place. You know, even though it's a multi-county public defender's office, you might only be looking at a half dozen in each county, and these people talk, they staff cases with one another. If you're not staffing it, first of all, this is going to cut out the chief public defender from staffing the case with them.
You gotta remember, I agree with you, because the notion of it being a multi-county public defender office in and of itself, those are generally the smaller counties. So they are gonna be, I mean, there's a lot of those folks, as you said, Fran, they have a lot of discussion, they don't wanna bounce things off of you, it's just a lot.
The appellate defender's not the public defender, the public defender might jump on this for ineffective assistance and also grounds on people.
And I think the judge just raised the big issue is in a multi-office district, the public defender is still the public defender. And so, and there's no way you can erect that wall. I mean,
And you want your assistant public defenders to be able to go to the chief.
That's right.
And other leaders in the office.
I wondered if they're gonna be able to wall off the material. I don't know if these various offices have access electronically to, you know, I'm thinking about Odyssey. Obviously now I can see stuff in all over the state. If their offices are connected electronically, do you inadvertently see something you shouldn't see? That then, now you've, broken the separation, the Chinese wall that you set up.
But that was exactly the point before, with the question about is it possible, and I just don't see that being possible at this phase. Because we already don't have enough resources to staff different public defender offices in the different counties, hence why they're, but in any event, we are at the place. Anybody else have any questions or any comments that you would like to make about this before we push this along? Okay. Do I have a motion to send this to subcommittee, as we all sound like we agree needs to happen? Yes. All right, we have a motion and a second to send this to subcommittee. Any more discussion? All those in favor, please say aye. Aye. Any opposed? All right. And I will get you.
Anybody want to volunteer for the subcommittee? My good friend Ellen right here threw her name in, so that's good. Fran?
Yeah, I'll do it.
All right, next, we don't have any ethics advisories. And then we have the last withdrawal of formal ethics opinion, 2005 FBO 8.
Yeah, this will be.
Not last, I'm sorry.
Right. This will be really brief. 2005 FEO 8 is a formal ethics opinion on the books that I feel is potentially causing more confusion because it is an opinion based upon a rule that no longer exists that requires lawyers to register their trade name with the bar. That rule, that requirement was eliminated when we amended the advertising rules back in 2020 or 2021. And there's no more requirement there for lawyers to register their trade name with the bar. They can certainly get advice on their trade name if they want, but the registration requirement is no longer there. So this is just simply one of those things we stumbled across because we do still get lawyers that contact the bar saying, where do I register my trade name? I saw in an ethics opinion that I'm supposed to register my trade name. I'd recommend that 2005 FEO 8 be withdrawn because it simply isn't applicable under the rules of professional conduct in 2025.
So moved. Second.
All right, we have a motion and a second to withdraw or remove this 2005 FBO 8. Any further discussion? All right, that's pretty straightforward. All right, all those in favor, please say aye. Aye. Any opposed, nay? All right. Next and last, approval for transmission to the council. Proposed 2024 formal ethics opinion 3, fee agreement requiring payment of estate planning lawyers' future legal fees.
Suzanne, you want me to cover this one?
Yeah, that'd be great.
All right, so 2024 FEO 3 was published this past quarter. It deals with that really tough inquiry that we debated for the past year on whether or not an estate planning lawyer can provide or can include a provision in the fee agreement that obligates the testator's estate to pay for any future legal fees associated with some sort of subsequent challenge to the will or what have you. You know, the scenario that we've discussed a number of times is that a estate lawyer drafts a will, 20 years later, the testator dies and the will gets challenged and lawyer gets pulled in for depositions and discovery requests and all these kind of things that essentially is unpaid work, and that can be substantial sometimes. So the opinion does conclude that yes, this type of agreement or this type of provision would be permissible, but provides really kind of the parameters under which that type of clause would be permissible under the rules of professional conduct. We published, and I have to say I was shocked we received no comment. I don't know if it was because everybody's just busy with the holidays or what. I know I had heard from a couple lawyers saying, I'm going to comment on that. I don't like that opinion. And we've received no comment. So I don't know that that is enough. The grumblings that are passed along. So I think as of right now, we have no formal comments. So the next step would be that the subcommittee has the opportunity, or really the full committee has the opportunity to send it on to the full council for adoption.
We talked about it.
It's time to let somebody else talk about it.
Such a good job with this.
Yeah.
All right, that's your motion?
That's my motion.
All right,
Second.
I have a motion and a second. Is it to send to council for adoption?
Yes.
Okay,
That's
so I have a
my
motion and a
I
proper
move that we
second
send it to the council for adoption.
to send to council for adoption. Any other discussion? All those in favor, please say aye. Aye. Any opposed? All right, send to council for adoption.
Do we want to talk about that opinion just one more time?
No.
We can talk privately.
We had quite a bit of discussion about folks no longer with us, issues. So I think I really appreciate the subcommittees, as I said earlier, for all the work that you are doing. This concludes everything that we have on our agenda. I appreciate you all. Y'all continue to stay safe and warm and all of that good stuff, and we'll see you at other meetings. And tomorrow, is anybody watching? I have no idea.